and welcome to this expert panel on promoting climate action through Europe and America's trade agreements, run by the Center for International Sustainable Development Law. I'd first like to introduce our two chairs for this session, Dr. Markus Gehring and Professor Jorge Cabrera.
Thank you very much. Welcome, everyone. It's great that you can join our session. We have a distinguished panel of presenters and commentators, and look forward to discussing some of the advances that we've seen in international trade, international investment, and especially with the focus on the European Union and Latin America. We have the following focus questions. How can international trade and investment rules foster rather than frustrate climate action? How are European and America's trade accords evolving? What climate innovations are being included? And what more is necessary? What are the lessons learned to date? And what changes should be made? It's a distinct pleasure to also welcome one of the co-leads and fellow lead counsel to the session, Professor Jorge Cabrera from Costa Rica, who's actually logging in with us from Costa Rica. So at a significant time difference. Jorge, welcome. Maybe
thank you very much, Markus. I'm very happy to be here and to, of course, be part of this distinguished expert panel and to share my views and thoughts with this with the colleagues, and especially to look at the outcomes of this very interesting research about how the trade agreements between Latin American countries and the EU can support and can foster climate change activities. Thank you very much.
Thank you, Jorge. And without any further ado, we should go to our very first speaker, Professor Javier Caceres. Is an instructor in the University of Chile and an international consultant in trade and development and a research fellow with the CISDL. She has written many reports inter alia for the World Bank, the Inter-American Development Bank, and ECLAC. And her research focuses on international trade, sustainable development, intellectual property, and investment. Javier, you have the floor.
Thank you so much, Markus and Jorge, for being the chairs of this panel. Well, good morning, everyone. It is my great pleasure to participate in this panel. And I don't know how much time do I have, Markus? Or
if you can keep it to sort of 5 to 7 minutes, that would be great.
Okay, perfect. Okay, so we don't have much time, but well, I'll present, so in this context, the main results of our study on the incorporation of sustainable provisions in Chilean preferential trade agreements. So as I don't have much time, I'm just going to start pointing out some of the main conclusions of the study, but the full report and other briefs from the project can be available at the CISDL website. And I also know that there is a summary of all the reports also being published at our website. So it's interesting for you to look into that. So, well, when analyzing the case of Chile, a progressive strengthening of their institutional framework towards the achievement of the Paris Agreement objectives has been followed, included in 2020 an update of its NDC. So Chile by law has established the goal of carbon neutrality and resilience for 2050 and recognizes, among others, the principles of non-regression and progressiveness. So in terms of the inclusion of environmental provisions within trade agreements, my research identifies 4 stages for Chile. So first, Chile acknowledged this issue through the inclusion of environment-related provisions in the preamble of agreements. Second, environmental-related provisions as part of cooperation schemes were included. Then the third stage included the negotiation of specific chapters on trade and environment, while the fourth and current stage has been characterized by the participation in state-of-the-art discussion regarding environmental topics. So the research assessed and compared how Chilean PTAs have incorporated environment-related provisions to analyze if it follows the current practice of environmental provisions in trade agreements. So for this objective, I compared 33 agreements subscribed by Chile between 1993 and 2022, and I divided this analysis into main sections. So first, a general agreement, the general agreements looking for the inclusion of environment-related provisions within the full body of the treaties, and another division which is based on trade and environmental chapters. So when analyzing the full text of the agreements first, I can state that 25 out of 33 agreements include sustainable development or environment-related provisions within their preambles. But also it must be stated that most of those agreements that refer to the promotion of sustainable development do it as a general commitment. So, well, few of them expand this to environmental protection. A second element that can be identified in the agreements is the inclusion of a relation with other agreements clause. So in general terms, this provision is included to reaffirm parties' commitments subscribed in other international agreements of which they are both signatories, which only 3 agreements explicitly referring to environmental agreements within this clause. Also, environment-related provisions can be found in cooperation chapters, either as a general area of work or included specific issues such as forestry management, biotechnological, agricultural, or climate change, as in the case of the agreement between Chile and Vietnam, Turkey, Malaysia, Indonesia, and Uruguay. An innovation in trade policy making can be found when referring to the inclusion of trade and environment or trade and sustainable development chapters. So to this respect, it is worth highlighting that in the case of Chilean negotiations, only 8 agreements out of the 33 analyzed included these kind of chapters or similar provisions. So when looking into the specific wording of the provisions regarding the objectives and aims of trade and environmental chapters, Chilean agreements contain statements that recognize the environment as, for example, one of the 3 dimensions of sustainable development, and that it must be addressed in a balanced manner with the social and economic dimension. So the objectives vary, but provisions have similar wording regarding, for example, the promoting mutually supportive trade and environmental policies, promoting high levels of environmental protection, promoting effective implementation of environmental legislation, capacity building between the parties, or also promote the use of environmental measures based on their legitimate objectives and not as a means of arbitrary discrimination or a disguised restriction on international trades, because yes, we're talking about trade agreements including environmental issues. So Chile's agreements are quite restricted when referring to broader international environmental agreements. So with respect to specific obligations, they are different across agreements in the number, types of areas that are covered. So in general, these specific provisions first recognize the importance of trade and environment matters. Second, they reaffirm commitments in MAAs or declare parties' commitments to comply with international obligations. Third, they can aim to promote and encourage the conservation and sustainable use of the specific matter. And fourth, they look into the exchange of information, experiences, cooperation in related matters among the parties. So also it can be stated that we're referring to the cooperation and exchange of information. There's a specific reference to the trade and environment committees and other committees throughout the agreement. One of the most interesting provisions included is the obligation not to weaken standards. So this provision aims to establishing a state of play and not to use environment-related weakening policies to enhance trade or environment. So, and also I can say that not all trade and environment chapters negotiated by Chile have these kind of provisions. In terms of transparency provisions, most agreements analyze contain transparency related commitments also. So these are not structured in what we could expect to be the transparency articles, but rather focus on providing opportunities for public participation and the establishment of contact points. So when comparing these provisions to the available draft of the Chile EU chapter, it is relevant to point out that there is a rather weak article called transparency, but no additional references are made to public communication or participations. When we talk about cooperation commitments, it's important that we have specific areas that focus on MAA. So for example, cooperation at the multilateral level, on trade environmental topics, on promoting practice and tackling specific issues within cooperation articles and thematic articles. So to finish, also I would like to refer to the enforcement. So trade environmental chapters negotiated by Chile are excluded from the main dispute settlement system. And in general, they have a separate consultation process aiming to amicably resolve the issues that may emerge. So the Chile's approach to disputes resolution is focused on solving matters amicably through consultations. So overall, I can argue that Chile's incorporation of environmental provisions trade agreements has evolved. So we see the general analysis shows that Chile has merely incorporated environment-related provisions as general commitments in preambles and within exceptions. So in fact, but there's also been an evolution in terms of cooperation articles that tend to include the environment-related issues and activities. In the trade environment chapters, we see that they recognize the relevance of the topics, but still we have not had enough articles with those kind of chapters. Sorry. And to conclude, I would like to invite you all to reflect on these issues, to see the paper in which we can find a specific comparison of articles and a most deeper analysis that I can talk to you about in this time. But thank you very much for your attention.
Thank you, Javiera, and thank you again for your work also in convening the roundtable on the EU-Chile relationship. We know that is one of the agreements that is closest, and of course we hope that some of our proposals and innovations can still be integrated, even though most of the legal text has already been negotiated. I think you highlighted the relationship between climate law and the Paris Agreement on the one hand and trade law on the other hand. And I think those kind of linkages are very important. In a slight change of the order, I'd like to give the floor to Alessandra Lemon, who was very much the author, the co-author of the EU-Mercosur updated report, where we compared the NDCs of all Mercosur countries and how these NDCs could be supported with a slightly revised text of the EU-Mercosur agreement. It's quite controversial in Europe, maybe less controversial in the Mercosur. But Alessandra Lemon, Dr. Lemon, has a degree in international law from the Universidad Federal do Rio Grande do Sul and an MBA from Gentilo Vargas. She is a partner in the Brazilian law firm, and Alessandra was listed among the top Brazilian environmental attorneys in recent years. She also plays a significant role in the Brazilian Bar Association and was one of the co-hosts yesterday of the IBA Climate Crisis Law event. And we're very honored to have you because you're on your way out of Sharm. Alessandra, you have the floor.
Markus, thank you so much for this extremely kind introduction, and also thank you for accommodating my logistic troubles. I am at an airport lounge in Istanbul. As Markus said, I'm heading out of COP, and So without further ado, I wanted to briefly present the substantive legal review that we recently performed in order to assess climate commitments in the most current iteration of NDCs from the four Mercosur countries. Identifying what we did basically was to identify highest priority climate change challenges and goals, and to compare them to climate commitments contained in the EU Mercosur FTA. So the reason we did this was to identify perhaps new provisions that could be proposed in the FTA to support current and future negotiations in view of climate priorities on both sides. So for the purposes of our analysis, I think it's important to bear in mind that generally speaking, the bloc's main exports are commodities, and GHG emissions chiefly derive from, on the one hand, agriculture and livestock, and on the other hand, LULUCF. So we also deemed necessary to specifically consider each country's trade profile as well as their GHG emissions profile. And while with this exercise of matching them, we thought it was important to understand these characteristics in order to assess whether sectoral climate policies drawn out in NDCs adequately cover each country's most prominent exports or not, and what measures should be prioritized in future negotiations. A few highlights. In the interest of time, I'm just going to do a quick overview. In alphabetical order, Argentina, basically, their 2021 NDC update states that it deals with key variables that account for major changes in the level of GHG emissions in the different sectors of the country. It expressly mentions population, GDP, demand and supply of energy, cattle, agricultural production, and changes in land use. However, it was deemed by Climate Tracker to show progressive ambition, but still rated as highly insufficient. So this is something that I think is important to consider with regard to Argentina's NDC. There's also a more general remark that I'd like to make, which is the fact that all four Mercosur countries' NDCs contain a caveat of sorts. They all state their low historical contributions to climate change by comparison to developed countries. Moving forward, Brazil submitted a first updated NDC on November 1st, 2021. I think it's interesting to mention that Brazil's NDC prompted a lawsuit challenging a change in base year emissions that would actually lead to increased emissions of 480 million tons by 2030 by comparison with the country's 2015 NDC. So Brazil presented an update on April 7th, 2022, which was still considered by Climate Action Tracker to be highly insufficient and not to have increased Brazil's ambition relative to the original NDC. Brazil's is a somewhat laconic NDC. It totals 11 pages. And I think it's important to mention that it mentions that targets will be translated into policies, into sectoral policies to be detailed and implemented by the Brazilian federal government, but does not further elaborate or specify those sectoral policies. As for Paraguay, I think what's most interesting about Paraguay's NDC with regard to their trade profile is that as a landlocked country, it pretty much focuses on adaptation. And also Paraguay's NDC is the only one of the four that highlights that the country maintains an economic system of free trade specifically. Finally, Uruguay, I think perhaps Uruguay, despite the fact that it was submitted in 1217, meaning that it's the oldest of the bloc, it's the NDC that draws the clearest relationship between trade and climate change, as it details sectoral climate policies that are centered around agriculture and livestock, which amount to 80% of the country's exports. Mercosur recently announced a sovereign bond program that is linked to sustainability goals. So I think that's also interesting to consider. And to conclude, I think that the general conclusion is that the current iteration of Mercosur countries and NDCs shows different levels of detail. And also as a general conclusion, I think Mercosur countries and NDCs, as well as the sectoral policies that are described in the documents, do not expressly consider, as a rule, the reciprocal implications of climate priorities in trade. So this relationship, of course, is very significant, and I think it should be leveraged both to avoid hindering trade and as a means to achieve the goals of the Paris Agreement. So, I think this would provide good opportunities to explicitly align Mercosur and EU climate priorities to their trade implications, so as to enhance implementation of climate provisions and to boost climate ambition in both contexts. Thank you so much, Markus.
Thank you so much, Alessandra. That was a really coherent and I think illuminating presentation and highlighting that maybe the current draft of the Mercosur agreement is not yet state of the art when it comes to trade and climate change provisions. The author of the magnus opus in this study, the synthesis report, drawing together all the bilateral analyses, is Marius Tokas. Marius is also the program coordinator for the CISDL Trade Investment and Finance Program. And he's going to give us an overview over the synthesis finding and some of the concrete text proposals that the researchers are making.
Thank you very much, Markus, for the introduction. And thank you, Javiera and Alessandra, for making the first introduction of the individual reports. So in our project, we examined the different EU-Americas trade and climate change relations, and in particular, their existing or other negotiation free trade agreements and their NDCs. In specific, we examined the EU-Chile, as Javiera previously mentioned and presented, the EU-Mercosur that Alessandra presented, and then we also examined EU-Andean Communities Free Trade Agreement, the EU-Central America Free Trade Agreement, and finally the EU-Mexico Free Trade Agreement and the under negotiation agreement in principle. So in the synthesis report, we also take a look at the different initiatives by other major trade powers such as US, Canada, Australia, and also the UK. And in the synthesis report and in the individual report, we provide proposals on how we can link climate ambition to an FTA and how we can make the text more climate ambitious, and with a particular focus on operationalizing the NDCs. And the idea behind the project, and we were very happy that we started early 2022, and throughout the process of 2022, all the developments were in the favor of what we were doing, because the idea was that climate ambition should be present throughout an FTA horizontally, not just within an environmental or a trade and sustainability chapter. And indeed, we're very happy that we saw in June the EU FTA strategy report, which essentially adopts this approach that the environmental protection, here we're talking specifically about climate change, should be present throughout a free trade agreement or an economic partnership agreement. And we also saw that the new EU-New Zealand free trade agreement and also the UK-New Zealand free trade agreement is a very ambitious, they're very ambitious treaties and follow basically the proposal we make. And to be very, very short, I would say that we present mainly 6 proposals, and 4 of them apply to non-trade and sustainability chapters, and 2 of them are particular parts of the sustainability chapters. The first one is that we promote very much a differential treatment in favor of green goods and services, which can be via the inclusion of an annex or provisions on green goods and services. And we have such examples with the EU and UK in New Zealand, and also we have seen outside of the EU and the UK, the Asia Pacific Economic Cooperation Agreement, where they have specific annexes on further liberalization on a list of green goods and services, which during the operation of the agreement, they have specialized committees which they can add or subtract certain goods or services from the list. And I would suggest to take a look at the UK-New Zealand Free Trade Agreement, because the annex is very, very detailed. It has details on how a particular good or a particular service promotes environmental protection, which is a very, very interesting, but also a very illuminating activity. So it can be used in the future by other trade partners as a basis, because it provides also the rationale. Second is to add flexibilities for green subsidies and additional disciplines on fossil fuel subsidies. And I see here we have Professor Larry Espa, who definitely will talk about this in further detail. But what I can very briefly say is that we have some examples of more regulatory space for green subsidies. The EU-UK Trade and Cooperation Agreement is such an example where they allow for certain green subsidies, of course, with under some conditions, in particular that they provide they provide affordable, sustainable levels of energy. They're indeed under market principles, so there are certain limitations. So it's not like a carnival, but still there is much more regulatory space than what we usually see under other subsidies chapters or under the WTO SCM agreement. And on disciplines of fossil fuels, both the EU and the UK, New Zealand Free Trade Agreements have certain disciplines, or at least they explicitly mention that we need to take steps to eliminate harmful fossil fuel subsidies, both within the FTA and also cooperate under the WTO to introduce such disciplines. And for me, it is very, very important that also they have additional cooperation transparency mechanism. A large part of both subsidies regulation and countervailing duties regulation is that there is lack of cooperation, there is a lack of transparency, and this asymmetry of information may create either distortion, because many countries may have different subsidy schemes to promote green and climate change transition, but on the other hand, they may also have incomplete information with regards to what do they have existing for fossil fuel protection. The third pillar, I would say, of our proposal is on the TBT chapter, again, outside of the trade and sustainability chapter, which is a promotion of regulatory cooperation, in particular on eco-labeling, or mandatory environmental standardization. And here it is very important to look at existing, especially in the EU, free trade agreements that do have provisions that put down specific strategies on cooperation on eco-labeling. There is, for example, the EU-Vietnam Free Trade Agreement that has a list, I think, of 7 or 8 regulatory steps, which include exchange of information, capacity mechanism, no capacity mechanism, allow me to rephrase, capacity building, technical assistance on eco-labeling. And also on EU-Singapore Trade Agreement, we have a specific chapter on non-tariff barriers to trade in renewable energy transition, which again include cooperation mechanisms, but also additional transparency mechanisms, in particular on how the parties introduce non-tariff barriers, particularly TBT and technical regulations with regards to energy transition. And also it is interesting to see enhanced transparency procedures and TBT measures, such as the CETA, that have a particular provision on climate change and particular procedures on with deadlines, with additional committees or swift response transparency procedures on climate change measures. And the last 3 pillars is first is facilitation of technology transfer in IP chapters for green technologies. Is something that we see under the WTO that is not done enough. And as we have seen recently with the COVID waiver, it's not easy to get any substantial agreement on any waiver with regards to climate change or green technology. So it is really important within FTAs, more mechanisms and incentives exist to foster transfer technology and cooperate on eco-innovation and renewable energy. And quickly, I would propose the EU Central America FTA, which has certain provisions, and it will be interesting to see how they will be implemented. And similarly, the EU CARIFORUM FTA, which has a list of specific measures that the party should take to foster eco-innovation. The last two pillars are within the trade sustainability chapter. The first one is effective implementation of the Paris Agreement with specific reference to NDCs and strict non-regression provisions. And very quickly, I would say what we propose already and the EU has included in its FTA report is that we need to have deadlines, we need to have steps and targets on effective implementation. So whenever we have a list of either of climate change agreements or it's just the agreements that were ratified, we need to have strict language with when and how they should be implemented, which of course they should include specific tools of implementation. For example, in the EU, New Zealand, we have emissions trading systems as part of implementing Paris Agreement obligation. In the EU, UK, we have carbon pricing. And further, we need to have an action plan where the EU, since it is the stronger, let's say, side of the agreement, which should have how we should cooperate and how should facilitate this transition and the effective implementation of the commitments under the FTA, which include commitments on climate change. And the final part is, since, and I see here Dr. Vidigal, since we have the question of CBAM, which is being introduced, a large part with regards to its relation to common but different responsibilities, principle is how the EU will be able to assist and cooperate with FTA partners to either create carbon markets that could be in accordance with the EU principles on the EU market, or how it will be able to assist through an FTA in creating similar instruments under the domestic law in order to, first of all, foster the reduction of carbon emission, but also to foster cooperation with the schemes that exist within the EU. And we have certain examples already, although they are either within the EU New Zealand or within the EU UK TCA, which again are like between developed countries. But what we can think of is that there need to be some equivalence procedures within the FTAs and some carbon certificate schemes that should be fostered under the FTA. I hope I didn't abuse very much my time, and thank you very much for listening, and thank you also for everyone participating in this panel.
Thank you very much, Marius, and I think we'll circle back to you after we've heard from the members, the distinguished members of our community of practice. Our first member is Professor Tobias Stoll. Professor Stoll is Professor for Public and Public International Law in the University of Göttingen. He co-directs the Institute for International and European Law and heads the Department for International Economic and Environmental Law. He serves as one of the directors of agricultural law in the faculty, and his research focuses on international and European law, particularly on economic and environmental law. And we couldn't think of a better intervener. I should also highlight that many on this call are listed as potential experts and arbitrators on the EU list. So there are limitations to what each of us can say in the context. And yeah, so we're all speaking in a personal capacity in that sense. Thank you, Tobias.
Thank you very much, Markus, and hello, anybody in the team, and good morning to Egypt. It's really an honor to be invited to join this panel, and has been an honor to be involved in the work of the Center for International Sustainable Development Law through the months where we have met in various kind of constellations to look into certain free trade agreements and negotiations. I think altogether we arrived at important findings, and I'm really saying that the reports given so far by Javiera and by Marius, but then also the important insights that Alessandra gave, really in a way are already explaining enough what we have been doing. So I don't want very much to add on this. First of all, let me say this project was really unprecedented, because in my view, it had very much, aside from producing a number of findings which are really important for the negotiation table, it also served enormously for building capacity and awareness among the expert communities, And also it linked those expert communities. And in this way, it importantly, in a way, contributed to a kind of an exchange at the academic level, but always very much focused on making a difference on the ground. So I like this very much. And I hope very much that this might continue, not least, of course, because after the political changes that we had seen, and also as Alessandra already in a way explained, the EU-Mercosur may come to the table very quickly and will give us a great opportunity to apply all the findings and carry on with this kind of a cooperation for this very important agreement. I only want to highlight, I think, 2 points that we have been looking at. I think we have seen important changes in the way free trade agreements mainstream sustainable development. There's been issues in interpretation, in specificity how to relate to multilateral environmental agreements and all this. But it is an important step forward to see that now sustainable development will not be any more compartmentalized in a trade and sustainable development chapter, but will influence the whole agreement. And the second issue is that we see movements in the question of enforcement. And this would allow us to importantly use this bilateral momentum that we see in trade agreements to step up and to feed in the international process of implementation of sustainable development. So much from my side, best wishes from Brussels, and with this I hand over to you again, Markus.
Thank you very much, Professor Stoll, thank you very much on behalf of the entire project team for your kind words. I should also highlight that we were impressed how many of the European experts were also fluent in Spanish and could intervene in the discussion very actively. Our next intervener is Professor Ilaria Espa. Professor Espa is a fellow lead counsel and a senior professor of international economic law at the University della Società Italiana. She's a senior research fellow at the World Trade Institute and serves as lead counsel for the Natural Resources Program in the CISDL. She's a world-renowned expert, as we've heard, on subsidies. And we look forward to hearing your intervention, Professor Espa.
Thank you so much, dear Markus, for this too kind introduction, and thanks a lot to your team for the important work you've been doing on free trade agreements by the EU and the Americas. I must join Professor Stoll in saying that it's been a great honor to be part of the community of practice you've created. It's been very enlightening, very challenging, very stimulating. And indeed, it has also been very stimulating to read through your reports, the synthesis report, but also the specific reports that you've just launched and published. And again, sort of in line with what was already mentioned previously, I would like to stress how seminal but also timely this work is in really disseminating more knowledge on how trade law, but also specifically preferential trade agreements can really foster climate efforts rather than frustrate climate action. And I believe this is very timely because we are really facing a particular moment in the trade community. I believe awareness has never been higher in the trade community on the urgency really to make trade and trade policy part of the solution to support low carbon transition. But at the same time, we also have a very now high awareness on the gaps that are still there to make it a reality. And I just would like to point out, in case any of you don't know, that just a few days ago, the WTO released its annual World Trade Report. And guess what? It's on climate change and international trade. And I think this is really an important message. I think we've already sort of come to know the new Director General wishes, and we know she has very strong views on sustainability and environmental sustainability, especially. And I think this promises well, especially if we look at the outcomes of the MC12. And I think not only MC12, which of course, the package may have some shortcomings, as we all know, but I think your work is really important if we look at this dialogue that's been made at the WTO, and in particular the fact that among the test items in the agenda are very high, precisely those items that Marius mentioned in your recommendations, right? Just to mention a few examples, so environmental goods and services for sure, subsidies, with particular respect in the test dialogue, of course, with respect to fossil fuel subsidies, but we all know that these are issues that the multilateral level is really struggling with since forever, right? Many years, sometimes even decades, if we think about the multilateral and plurilateral negotiations on environmental goods and services. And I think this is the real importance of the community of practice and of your reports, right? The report really highlights with concrete example taken from the most innovative PTAs, not always the EU Americas PTAs, but certainly some of the PTAs that have either been negotiated by the EU or by certain of the American states that the EU is actually also concluding PTAs with. Concrete example as to how we can shape and design trade provisions in a way that is instrumental to achieve climate goals. And I think this is really important. If we look, for instance, at environmental and goods and services area, as Marius mentioned, we do have a number of very nice examples in the recent negotiating history. Just look at the EU-New Zealand agreement, and as Marius also mentioned, the UK-New Zealand agreement. It is not by chance that those are agreements concluded by New Zealand as well, because we know that it is part of the ACTS negotiation that is really set to become probably the most ambitious trade-related agreement on climate change-related provisions. And if we do look at subsidies provision, I don't want to make a whole intervention about subsidies. We do see that, again, it is the UK-New Zealand free trade agreement that provides for the most innovations on that respect. We could even ask ourselves, why is it so important to have innovative provisions on the subsidies field? Because we do know that based on WTO jurisprudence, even if we do carve out, for instance, a number of green subsidies or clean energy subsidies, there will still be the possibility for members to bring a challenge before the WTO dispute settlement system. Still, I do believe that politically speaking, it would be really important and instrumental to building consensus bottom up with a view to prospective multilateralization. And I think this is my main message. Your work is not only up to the point and innovative, but also specifically timely, because through the PTA's examples that you bring, we can also push, and this is really the right moment to push and put a heavy load of momentum also on the multilateral processes. And so thank you very much for your very important reports.
Thank you so much, Ilaria. You almost made me blush. It's particularly important coming from such an eminent expert like yourself, who has been in these debates at the multilateral and at the regional and bilateral level for so many years. We were greatly inspired by the ILA Green Economy in Trade Agreements report, to which you so actively contributed. Our final speaker for this panel is Professor Geraldo Vidigal. Professor Vidigal is a professor at the University of Amsterdam, where he lectures international trade and public international law. Prior to that, he worked as a dispute settlement lawyer at the World Trade Organization Legal Division and as a senior research fellow at the Max Planck Institute in Luxembourg. He's managing editor of Legal Issues of Economic Integration and publishes regularly on international economic law and dispute settlement. And we were all inspired by his recent analysis of the CBAM. Geraldo, you have the floor.
Thank you very much, Markus. Thanks to you, to Marius, and to the whole team who's really doing a stellar job in advancing research and discussion in this field. And thanks for inviting me to give this particular talk. Now, I think you have said a lot, so let me. I think what I can contribute now is just to try to structure the discussion into types of provisions in trade agreements that can contribute to climate change, and to think a bit about where we are and where we can go. So, I mean, we can divide provisions. You know, I mean, there are lots of classifications, but one of them is to say they can be prohibitive in terms of behavior, permissive, and procedural. Right. So in terms of prohibitive provisions, we can say, well, there's some things we can do better. You know, currently there are the idea that there's non-regression, there's commitment to follow the Paris Agreement targets, and I think there, let's say, we can increase the relevance or the constraint imposed, but I feel that this is going to be a process that will be taking shape at the multilateral level, and what you can do with the trade agreement is really to integrate it into the agreement so that you can use this trade instrument as a means of enforcing, if you want, or committing bilaterally to complying with climate objectives, which otherwise don't have weak, let's say, enforcement in terms of international legal possibilities, right? And then the permissive provisions are interesting because, of course, then you'd have to ask what are countries unable to do that we would like them to be able to do. And here it gets more contentious, of course, because let's say the big issues now that are happening in this field, in the field of trade, is that the EU and the US are proposing, at least, and likely adopting unilateral measures that impose on other countries, or I mean, you can always say that they're actually imposing on their own consumers the obligation to pay for climate, the obligation to pay for climate damages, or for the cost of decarbonization, even if the production happens abroad. And of course, this is happening not only with respect to trade, but also in terms of all of this supply chain legislation, which does essentially the same thing to say, well, European capital, if it explores, if it leads to production abroad, also has to comply with this legislation. And this is likely to be problematic from the point of view of international law. I think it's always possible to design it in a way that it is compatible with WTO in a legalistic sense, let's say, well, in the sense that, a panel would be able to use Article 20 to get here and there, and we can say that this is a legitimate objective, etc. But it clearly is structured. It creates problems for how we structure international law, right? Where countries are supposed to be sovereign, and then there's this whole question of whether this is actually some form of imperialism or neocolonialism. And I think trade agreements would be a great tool to get around that and say, okay, well, we really are making here a bilateral commitment in which we consent to these measures, and therefore you do have specific consent to the measures, and you can also negotiate the means, because often what happens is these measures look very good on the surface, but when it comes to their implementation, it's very difficult, and they don't take into account of the specificity of each country and how their institutions function, how production is organized there, if it's informal, for example. So I think trade agreements could be a window for this to be both legitimized and also protected against future government changes, right? Because I mean, right now it seems that we have governments coming in Latin America, and also, I mean, also in the United States and Canada, of course, which are understand climate change and are for addressing it, but how do you protect these policies from political change. And one way to do it, of course, is to use trade agreements to say, okay, well, if you want to reverse course, then you'll be accountable to another country and not due to them being coercive, but because you have signed up this agreement and you have to abide by it. Which brings me to the third type of provision, which is the procedural ones. So who can claim who can demand compliance, especially, of course, here we're back to the prohibitive. So what does the agreement constrain, and who can demand that the country complies with its international commitments? And here I think we are still very much at the bilateral stage for most trade agreements, at least the EU Americas trade agreements, where it's really, you really depend on the other party taking up the issue internationally. And but of course, that's not the only possibility. You could also have individuals in the other party being able to bring disputes, or at least provoke their governments into bringing disputes. And I think here the EU is doing quite some interesting job in opening the procedure with respect to sustainability provisions to persons that are not necessarily that it doesn't require a high level political decision, but that you really have a process that is open to NGOs, to trade unions, and even, and I haven't been able to follow up on that, how that's going, but I saw that Peruvian and Colombian miners were asking the EU to enforce the sustainability provisions in the EU Peru-Colombia trade agreement against their home countries. So that's an interesting development, and it shows there are possibilities. And you could even think of, a sort of human rights approach to this, right? Where a country wouldn't even need to go a person or a union that believes the provisions of the agreement are being undermined or violated, doesn't even need to go to the other party. It can just go and demand a panel. I don't think we're there yet, and I think we're very far from it. But I think in terms of thinking about, to use our institutional imagination, we could think about more provisions that don't depend on the high-level political decisions, so that is let's say the commitment is really enshrined in law in a way that becomes self-enforcing. And I think I'll leave it here. Thank you.
Thank you so much, Geraldo, and I couldn't agree more. I should perhaps highlight to the audience that our reports were very much inspired by trying to find feasible language, not language that would be unacceptable for either trading partner, but rather trying to paint a very realistic picture. So let me give the floor back to Alessandra and Marius for a short response. So Alessandra, Geraldo and before him Tobias and Ilaria sort of highlighted to a certain extent that the move to sort of move climate change and sustainable development out of the silo into the sort of main dispute settlement part is a welcome move. Now, that is not yet included in the draft EU-Mercosur agreement. My question would be, from a perspective of a Brazilian lawyer, would you agree that such a change to the treaty text would be useful? And if the treaty text cannot be changed even under the new Brazilian administration, what other measures could we take in order to sort of highlight the importance of climate change and the sort of non-regression on deforestation objectives?
So yes, absolutely. I think I've been working with climate change and climate law for the past 2 decades. And one of the things that I've been able to observe is that climate change has moved out of a silo, generally speaking. It used to be a niche subject which has recently become mainstream. And this also reflects on, of course, on its relation with trade. I think this is an extremely welcome movement. And but Markus, you're exactly right. I mean, it's the EU Mercosur FTA is pretty much limited when it comes to climate change to very generally stating that the goals of the Paris Agreement must be complied with. And in that sense, if we are able to establish a new dialogue with the new administration and Brazil as the biggest economy of the bloc, I think perhaps this could be an important step in detailing, and also an important tool for implementation of climate change provisions when it comes to its relationship with trade. So I might be stating the obvious, but I think the new power dynamics and the new geopolitical and diplomatic relations that Brazil's new elected administration will be able to establish may play a very important role in that sense. So this is definitely something to keep track of.
Yeah, fantastic. I mean, we can't sort of completely predict where the new administration is going. It might be slightly skeptical with regards to new trade commitment, but the EU-Mercosur relationship, as we've seen in our 2001 report and the new report, it plays a crucial role, I think, for both sides of the Atlantic. I wanted to give the floor also back to Marius. Marius, you have rightly highlighted that there are quite a few steps, realistic steps, for innovations that we can take with regards to increasing the climate ambition of EU trade agreements. You also sort of welcomed the recent changes. My question would be, now the renegotiation of all existing free trade agreements would take quite a bit of time. Are there interim steps that could be taken in order to sort of rebalance the trade and climate change relationship? Marius.
Thank you, Markus. Well, there's always like an interim, like we saw now in the EU-Mercosur, there were some reports recently that the EU is thinking about adding an annex to sustainability. So instead of going through the whole legal scrubbing of the chapter, they will just add an annex. So as long as, and I think it's generally true for FTAs, as long as the FTA does not prohibit something, you can always have, as a subsequent practice of the FTA or as an additional annex, to add further climate ambition. And I think a good example is the recent Singapore-Australia Green Economy Agreement. They agreed on the basics, what we are going to discuss in the future, and gradually through the implementation, they will add more and more. I think the first chapter now will be on green goods and services, and then they will add more as we go forward. And this is what Ilaria said with regards to, if we start something on the FTA, this can be expanded afterwards to either as best practices to other trade partners or among trade partners, and also the WTO. So for example, for many years, we could never agree on an environmental goods agreement. But since for the first time we have some agreements, even at an FTA level, this can be used by other parties. And we have seen the unfortunate side of this when you had BITs that agreed between parties that were copy-pasted by other countries without really negotiating. I hope this can be on the positive side right now for climate change, when you have an established set of a list of green goods and services which will be imitated by other countries. And the second side here is that we need truly to see in terms of the implementation and enforcement of the free trade agreements. And I'm following up on what Tobias and Geraldo said, that we need to see at the FTA level what is happening on future development within the committees, like how you will be able to represent better what the NGOs or the various trade or environmental unions will say within the committees, how the different provisions, the best efforts provisions on, let's cooperate on this, let's cooperate on that, how we truly will see within the particular provision, the IP committees, the sustainability committees, truly to see future projects or future positive commitments by the parties on implementing those provisions. And this, even under the existing FTAs, this can still be done. The language is open-ended. It has best efforts. It may not have what we call for like positive obligations, positive commitments, but still, since it is open, we really need to see the parties and the EU in particular to take a step forward. And we saw that in the 2022 FTA report that we need to take a step forward to effectively implement through the different committees and the different institutional arrangements within the FTAs.
Thank you, Marius. And in our reports, we've very much sort of taken the NDCs seriously and asked the question, how would we change trade agreements if they really took the NDCs into account? So one way is linking to NDCs, linking to NDC compliance. On the other hand, there are also voices in the literature that say, well, we're negotiating climate on the one hand and trade on a completely different hand. So I wanted to go briefly back to the experts and ask them, is there perhaps a challenge with regards to using the NDCs as a legal sort of yardstick for trade commitments? Tobias, are we playing a little bit with fire with regards to that, making that kind of linkage?
Yes, thank you very much, Markus, for this question. In all the development about FTAs and taking on board sustainable development, we often have discussed the kind of relationship between, be it climate change or climate protection and trade or something like this. And I always say that we can understand this linkage to be on two levels. First of all, there might be an economic level. So we might say on the real world economies, what would climate change policies would have an impact on a particular trade or potential trade. And the second one is a political link. So we understand that trade agreements negotiations offer the opportunity to take on board climate change issues. Certainly, I'm very happy to see that nowadays in the agreements that we have analyzed, the link between climate change and trade is not made in a kind of a limited way, so to say that we are only looking into those climate change issues which have a direct impact on trade. We are going far beyond this. I think sometimes we haven't even noticed that we were doing so. We offered a new kind of a bilateral law of cooperation on climate change and sustainable development, which is still linked with a trade agreement, but substantially it's not linked in a kind of a limiting way. And we have to think about it to fully, in a way, to explore the potential which we have at hand, and also to see how it is appropriately done. Because think about those negotiations, which are basically trade negotiations so far. So if we would understand that all our discussion about climate change in those negotiations would be on the same track of reciprocity that we apply to market access, then this would be a bad story, saying so that one party coming forward and saying, well, listen, could we have more ambitious climate change obligations? And the other side would say, well, if you do this, or if you want us to agree, then we would like to ask for this and that kind of a market access commitment. We have to understand that there's a different rationale between international trade law, which is very much based on the idea of reciprocity, and then international sustainability law, which is very much based on cooperation. And that has to be made clear. And I think we already have, at least in EU free trade agreements, we already have this structure at hand, because in many cases we call them now not anymore free trade agreements, but larger agreements. And we have to see that there are certain very specific trade-related provisions, but that overall the agreement is in place to establish kind of a very much more intense and much cooperative relationship between the countries. And perhaps we would have to make this clear, because I would not like to see us to say, well, listen, the other country is asking us for more climate change cooperation, but we are not in a position to do more on market access. So unfortunately, we cannot agree. I would not think that would be a good idea. But thanks to the question, I think that is a question of the future, to the future development of those trade agreements. Markus.
Thank you very much, Tobias. I couldn't agree more. We're almost at the end. I wanted to circle back to Alessandra coming in on this. Alessandra, please, you have the floor.
Thank you. Just very quickly, this is something that I wanted to highlight. One of the conclusions of our analysis is that while it's true that NDCs are quite generic when it comes to trade aspects of climate change and trade impacts of climate change, one possible avenue to further detail the relationship between climate and trade is this sort of this new type of architecture that emerged at COP26, which consists of sectoral agreements, which are in turn directly linked to each country's export and trade profiles. For instance, we have the Global Pledge on Methane, which is directly linked to the production and export of livestock, and also the Global Pledge on Deforestation, which is also directly linked to the production of commodities. So perhaps there is a possibility of further exploring the relationship between trade and climate in relation to these new type of architecture.
Thank you very much. Thank you to everyone who did the hard work, who advised us in our community of practice. I know it's now 3 a.m. where Jorge Cabrera is. Jorge, did you want to say a few words, maybe even in Spanish, to conclude this panel?
Thank you very much, Markus. I'm still awake. It was quite interesting, so I remain here in Heredia, in Costa Rica. Yeah, it's 3:24 actually in the morning. No, it was really an amazing exchange of views. Actually, we're really proud of the outcomes of the research done by the CISDL people with the support of the community of practice and many professors and many lead authorities in the field of trade and sustainable development and climate change. I very much recommend you to look at the synthesis report and to each of the specific reports on the different trade agreements made by the EU or in the process of renegotiation. It's a lot of information, analysis, and recommendations. So I think this is an issue to be discussed, of course, in future events. I mean, these linkages between the trade regime, the climate change and sustainable development, and how we can improve climate change and sustainable development goals through trade agreements. And this is an open question. There are many now fora or activities in which this is under review and discussion. So perhaps just to say thank you to all the participants and to recommend very much for the participants and everybody involved in this and interested in these issues to look at the several reports produced by CISDL. Thank you very much.
Thank you very much to everyone, and that concludes our session. Fantastic participation, and we look forward to continuing the discussion because as the EU moves forward with these bilateral relationships, I think we will see more questions being raised, especially with regards to climate change. So thank you very much. Thank you from Sharm El Sheikh and the COP27. We look forward to maybe hosting some of you in person next year at COP28 in Dubai. Thank you very much, and goodbye from me.